Manever I say ma PENDREAM TV. PENDREAM TV there, I see them yopo.
Right? Yes, so let's look into our history. This is not the first time. So let's stop being enablers. Let's stop being enablers. The fact that somebody is your relation and is in government doesn't mean that you can't speak up. See something, say something, sorted. Thank you.
I appreciate it. Thank you very much. And this week, we saw a lot in terms of the special prosecutor's work in this SML matter. In fact, for the past couple of weeks, we've seen some movement in that area. And I start off this conversation with an article that I saw authored by Jimmy Agla. Good morning, Mr. Agla. It says, public office in Ghana is like a mango tree in your neighbor's house. You didn't plant it. You didn't water it. But when the fruit ripens, your only job is to climb, pluck, and share the spoils, preferably before the neighbor notices the tree was ever theirs. In this beloved Republic of Ghana, corruption no longer hides under desks or behind curtains. It wears a three-piece suit, holds a press conference, waves politely, and proceeds to collect its shares before the meeting even starts. We have turned corruption into an art form, off-key, yet performed with such national confidence that even the audience forgets they are being robbed mid-performance. Public office in Ghana, indeed, we condemn corruption passionately. We mount platforms, we quote scriptures, we shake our heads so hard you would think integrity is suffering an earthquake. But behind the scenes, envelopes slide skillfully under tables. When we started this conversation on this particular press conferences by the special prosecutor, questions were raised as to what's the end game? What is he going to do beyond telling us what has happened? If you recall, the last time he spoke about SML and the investigations in there, and the officials who might stand trial, and some of them having the OSP's investigation have bought apartments with some of the monies that the OSP suspects were gotten out of corrupt and corruption-related activities involving these persons. Take a look at this.
Contractual arrangements between Strategic Mobilization Ghana Limited and the Ghana Revenue Authority for the stated objective of the enhancement of revenue assurance in the downstream petroleum sector, upstream petroleum production, and minerals and metals resources value chain. 2. Termination of a distribution, loss reduction, and associated network improvement project contract between the Electricity Company of Ghana Limited and Beijing Xiaochen Technology BXC. 3. Procurement of contractors and materials and activities and payments in respect of the National Cathedral project. 4. Activities and payments in respect of a contract awarded by the Ministry of Health, initially commenced by the Ministry for Special Development Initiatives to Service Ghana Auto Group Limited for purchases and after-sales service and maintenance of 307 Mercedes-Benz Sprinter 305 CDI ambulances for the National Ambulance Service.
Well, that's Kisieja Beng there. And these three persons were amongst 8 individuals who were arrested this week by the special prosecutor. Let's put them on the screen right now. These are a former Commissioner General of the Ghana Revenue Authority, Reverend Dr. Amishaddai Osuamwa. And then also we have Dr. Isaac Crensel and Christian Tetesoti, both former top officials of the Ghana Revenue Authority. Reverend Dr. Amishaddai Amwa was a former Commissioner General of the Ghana Revenue Authority. These were the first 3 who were arrested, and then some of them granted bail. And then later, we got to know that after these persons were arrested, there were additional persons as well. Ivan Seduse, Chief Executive Officer of SML, Ivan Seduse, and then one Philip Mensah, a former Deputy Commissioner in charge of legal at the Ghana Revenue Authority, is now a legal consultant to SML. And Kofi Nti, also a former Commissioner General, and Joseph Kuruk, Public Procurement Authority official, and together with Faustina Ajoko as well. And all we saw with this particular SML deal, as we do know, the number of infractions that the KPMG report even reported or captured. We don't have the full complement of the reports, but we know that the highlights that were released sometime last year was even pregnant with so much detail. It got a lot of us thinking and concerned. If you look at the evolution of this contract, right from the period when, according to the KPMG report, SML changed from SMEL, which was to provide transaction audit service. On the 22nd of November 2017, they changed their names to SML. Fast forward, GRA extended the transaction audit with SML. SML then transitioned to become the main contractor without, take note, without Public Procurement Authority approval on the 1st of January. This was 2019. Fast forward, we saw how it all played out. They didn't even have parliamentary approval based on what the KPMG report said. There was no needs assessment made as to exactly what was needed and why this was being engaged. According to the KPMG report, even the rationale for the procurement was made without any needs assessment. The SML provision of services was also without a Public Procurement Authority approval. The contracting of the SML was without GRA board's consideration and approval. There was no deduction of VAT by GRA for an 8-month period on payments to SML, which resulted in the loss of over 13.38 million Ghana cedis. That's financial loss to the state, essentially. And this was a period between 1st September 2020 and 30th April 2021. And then all of this, according to the KPMG report, all these laws, they said they identify potential breaches. The 1992 Constitution of the Republic of Ghana, GRA Act, Public Financial Management Act, National Petroleum Authority Act, National also Value Added Tax, Public Financial Management, Petroleum Commission Act, Minerals Commission, Precious Mineral Marketing Company Act 200-461, Ghana Standards Authority Act 2022. All these said there's potential breaches that the SML contract captures. How much people? I mean, here in this week, this action by the special prosecutor, these 8 persons who were picked up, and I mean, look at their profile: former Commissioner General, Deputy Commissioner. All these persons involved based on the OSP's arrests and how this case has evolved till this point, where we've seen some of these persons, top echelons of the GRA, also being picked up within the week. How do you see things playing out? Very quickly.
Well, it's the right thing to happen, right? Finally, at least finally, there's some accountability. Because, you know, Mr. Kansi, when this story broke, right, in the previous administration, you know that because Akufo-Addo was in the business of clearing agent, he quickly got KPMG to do this audit. You know that KPMG had been quite charitable to Akufo-Addo. You remember a lot of civil society organizations said, no, KPMG shouldn't do this job because it had too many government contracts, was too close to Akufo-Addo's regime. They did it, and even you see with KPMG, so we saw a lot of bad stuff going on. Of course, if we had a more independent audit firm, we expected that the results would have been worse. So the key thing is that it's good that the OSP is also, you know, finally coming up to speed to some extent on this matter, right? Because you know that OSP was being gagged. OSP was being gagged. You remember the Kisi Ejabe's famous Ankwanuma press conference where he kept asking Ghanaians, are you ready to fight corruption? Are you ready to fight corruption? Are you ready to fight corruption? Right? Yes, he did well, but he stopped short. He didn't match up to Martin Amidu, who could specifically call out Akufo-Addo's henchmen who were gagging him and frustrating him. And that's one thing I consistently remind Kisi Ejabe that he has to do. Look, sometimes this fight, if you want to do, he who fights and runs lives to fight another day, they may not be that other day. You see that though Martin Amidu didn't stay in that office for long, you know that when he came to the famous Ejapa deal, he called out names. He mentioned how the president and Ofori-Atta tried to interfere in his work. Of course, he should have stayed on. The fact that Amidu says Akufo-Addo asked him to give Ofori-Atta a hearing shouldn't have been enough for Amidu to resign. But that's the kind of examples we want Kisi Ejabe to live up to. Yes, Martin Amidu didn't stay long enough to do court cases like Kisi Ejabe was doing. But when Amidu had the opportunity, he was very clear. He was clear. He named and shamed people who tried to interfere. The only time I've seen Kisi Ejabe come close is what he did to Professor Jampo, that Jampo had contacted him. But that one wasn't sufficient. Kisi Ejabe, you know very well how Akufo-Addo's ministers and government appointees came to you. You never reveal those people. But Jampo, like they say, Koto Nobodre, right? So Jampo deserves to be named. But when, what do you call it? Akufo-Addo's henchmen and even Akufo-Addo himself was frustrating, you weren't bold enough to name them. But now you would want to name Jampo. I looked at it and I laughed. I said, what? Jampo's communication with Kisi Ejabe didn't go far enough to merit what happened. The people who sought you, even look, if you take the NDA case, the NDA case, Kisi Ejabe slapped the people with soft offenses.
Why do you say soft?
Yes, initial, just the procurement offenses. It was Isidore Tufuo.
But is that matter still running in court?
Yes, they've opened their defense. So Isidore came in, reviewed it, and now ratcheted up the offenses to proper corruption offenses. This was playing it soft. Look, even Akufo-Addo's friend, Napaga Clara Sulemana, because of her closeness with Akufo-Addo, she was in charge. The main person, this NDA case, Napaga Clara Sulemana, she had to, approve. The final madam to approve the transaction. How come you charge all the people and left her? We all know that she's close to Akufo-Addo. Very close.
I get the fact that I know you were neck deep in this case.
Yes.
Let's redirect back to the SML.
Yes. So what I'm saying is that, OSP had been slow, in coming to SML, had been slow. But finally, it's okay that they've come. Because I thought that, in September 2023, they got a lot of employees, right? Parliament approved earlier in the year for them to employ over 200 employees, around 230 something, right? Yes, of course, not everybody would have taken up the position. But with the numbers increase, one would have thought that some of these cases, it would have been, they would have gone much faster because it's now that this, what do you call it? Amishaddai, also Abuaji and co have been arrested. It looks a bit slow. You have to decentralize. The system itself was too centralized, and it's still too centralized around the OSP. So remember earlier on, I'd mentioned that look, when petitions go there, it shouldn't be left with Kisi Ejabe alone to look. It should go to a board so that there's transparency. There's transparency because some of these cases, I'm sure if the other directors were put in, like a petition arrives at the OSP, it goes to the whole board, a committee that looks at it, there will be much speed. But where everything is centralized around the OSP, you won't get the desired speed. If we don't hold the OSP accountable, we will not get better results. So we shouldn't be shy. I'm not shy to support Kisi Ejabe. As and when I also feel that we have to put in fire for him to be more transparent in the work, etc. We have to. There's no space for shyness or the fact that I've known Kisi for over 20 years. That means that we shouldn't say anything. He's known Jampo for over 20 years. They were mates, in Lagos. But still, he put Jampo on the spot. So it's the same thing. We all, this matter of, oh no, don't shake this table, don't rock the boat. It's not getting us far. No, we have to hold government institutions accountable. So SML is come on. These are arrests. You know, every two lawyers are here, ABG and then a lawyer. Kwesi will tell you that as for arrests, it's just preliminary. So rather than start celebrating now, we'll wait for the day the case will make it to court. We'll wait for the day the case will make it to court. Because today is what, 28th?
Today is 28th.
28th. You remember the MPA, Mustafa Hamid's MPA. Kisi promised us that by end of the month, the case will be in court. Today is 28th, Saturday. So Sunday 29th. So we have Monday. Okay. Yeah. So Kisi, there have been gentle reminder. From the way he said it, I thought that by now it should have, made it to court. But 28th, we still haven't heard anything. Well, okay, we'll wait till Monday. You see. So let's see. So SML, arrest good. But please, we all know, you can arrest somebody and keep him in custody for 100 years. If the case doesn't go to court and if he's not convicted, we haven't done anything against his record, apart from maybe having incarcerated him, kept him in custody for maybe a few days. So I wouldn't celebrate too much the arrest, because the arrest in itself is not a criminal conviction. So I'd rather continue to urge OSP to double up, and then let's enter court, because that is where the real game is, and then they would answer. Yes, okay. Yes, that's what I'll say for now.
Well, and talk about the NPA, because you just referenced that the current CEO of the National Petroleum Authority is just joining us in the studio as well as a private legal practitioner in good standing, Godwin Edigi-Tamaklo. Good morning. Thank you very much for joining us.
Good morning to you, Alfred. Good morning to your cherished viewers and now online listeners.
Indeed.
Yes.
Indeed.
And my distinguished learned senior, my friend.
Thank you.
My friend.
Thank you.
There's nobody who knows sports law, football law than this man. Anything GFA related, sports law and everything, he's a go-to person.
Thank you.
Maintain that relationship for a while.
Thank you.
I want to thank you for the platform. Yes, I know the circumstances under which I have to be here.
Indeed.
So once again, good morning to everyone. That said, you see, aspects of the SML investigation directly impacts on the work I do. Because of the revenue assurance bits in the downstream petroleum sector. Remember that this whole thing is a contract for revenue assurance and the subsequent consolidation of the agreement. And the whole idea to, as it were, audit the petroleum downstream. Exactly the place that I basically sit as the acting CEO. I am aware that my office has been cooperating, and some of my officers have been cooperating with the Office of the Special Prosecutor on this particular SML investigation. A lot have gone on. So in terms of the merit or otherwise, I'm a bit constrained, because who knows, I may be called as a witness maybe in this matter, in the sense that, you see, most of the claim relates to whether or not, and from Manasseh's write-ups, and remember that they originated this whole investigation. Manasseh, the Fourth Estate, among others.
Yeah.
And the claim has always been that there was no need, right, for the SML engagement. Because the NPA was already in the process of doing that revenue assurance. Because they're able to generate the data, and we have other schemes in place that allows for the issues of pricing the issues of ensuring that products are not diverted, among other things. And so, to Manasseh, there was no need at all for the contract. Those who signed it also believe that there was. So far, so I wouldn't want to comment so much into the merit. The only thing I want to say, that a few things strike me when the OSP announced that they are effected some arrests. I found it extremely curious, and here is my curiosity, that some named officers of SML used to work with GRA.
Yes.
The contracting party.
Yes.
In the sense that it appears at the time when the contract was consummated, the CEO of SML used to be a technical advisor to
the GRA.
One wants to find out the nature of disclosures relative to our conflict of interest laws. What were the nature of disclosures that were made prior to engagement? Is it possible that a technical advisor to GRA, upon leaving office, can immediately engage in an activity with a company that, say, obtained a contract at the time that he was working there?
Right.
They have also mentioned that there used to be a lawyer for GRA,
Philip Mensah,
who today happens to, one way or the other, either consult for or work for.
Okay, so that's Philip Mensah, former Deputy Commissioner in charge of legal. He's now serving as legal consultant to SML.
And others. That is where I find it a bit curious. At this point, I will hasten slowly in making any imputation of crime or otherwise. What I do know, that there are clear rules on conflicts. So, for instance, today, I act as deputy CEO, act as CEO or of the authority, and you have a situation where I am no longer in that office. A contract that was signed under my tenure, a company that, say, obtained that contract, I am no longer at MPA and now consult for that company, or I now work as CEO for that company. You see, for us public servants, the responsibility on us a bit more higher. We are put in a situation where we need to conduct our affairs like Caesar's wife. You know, there shouldn't be a circumstance where Caesar's wife will get to a point where there will even be rumor that Caesar's wife, Cleopatra, has anything to do with Mark Antony. We shouldn't get there.
Indeed.
You understand?
Yes.
As human institution as we are, maybe with the benefit of time, we would understand exactly what informed the decision by these gentlemen to be related by way of working relationship with a company that obtained some contractual relationship with the Ghana Revenue Authority. More importantly, at the time when the one way or the other worked. Does this suggest some level of insider trading? These matters will be coming up at the right time. But like I pointed out, because of the cooperation between the agency, the authority ahead, and the Office of the Special Prosecutor, I would want to leave the merits, the nots, the have-nots, for the purpose of this discussion.
And I respect that. I respect that. And you talk about some curiosity, something that you're curious about.
Yes.
Is it what you spoke about, or exactly what tickles your curiosity about this matter?
The point.
As it has evolved to this point? Maybe very quickly. I'm not going to indulge you too much.
Yeah, the point I'm making is that imagine me at the CEO of MPA acting, I enter into a contract with a company called Martin Kwebu and Sons Limited, or Martin Kwebu LLC, to do revenue assurance for the authority. Now I leave the authority, okay, and Martin now employs me, right? Employs me as the CEO of the company that obtained a contract at the time when I was CEO. It may not be, but it will create an impression that the contract was prepared ahead of my leaving the authority. Do you get it?
Yes.
And like we always say, a multitude of suspicion is not enough basis to ground criminality.
Yeah.
But that threshold, should we get there? So I am a bit mindful this morning not to say ABC. Look, on the issue of Procurement Act, I think that I have, within the past 12 years, litigated the Procurement Act very well in our court. I've litigated it so well. I've argued many aspects of the Procurement Act. You recall, in the NCA matter, my clients were convicted for breaches of the Procurement Act.
Yeah.
I remember vividly before His Lordship Justice Chebafo, when I made this argument that under the Public Procurement Act, a breach does not automatically result in criminality unless you are able to establish a mens rea, because the Procurement Act did not create a strict liability offense, so that a breach is a breach. It's like traffic offense. Once you cross the red light, no explanation is enough. Strict liability. My argument was the reverse, that under the 1992 Constitution, you must first establish that at least there is a mens rea, and then there is an actus reus. You must establish a guilty mind. You must establish that A, B, C, D. That argument, even though attractive, did not find favor with His Lordship Justice Chebafo.
Yeah.
And therefore proceeded that to the extent that my clients entered into the contract without the approval of the PPA, it constituted their guilt and convicted them 4 years imprisonment. You understand? I remember in the Atofose matter, Sylvester Animana was also charged for breaches of the Procurement Act. In the Opuni matter as well, and many, many other such. I think that we've possibly gotten to a point where we may have to look at the act again. What's the threshold of guilt? Is it the mere fact that a contract was signed into without? If that is the law, like somebody said, the law is the law.
The law. We know who said that. Yes.
You understand? That's one aspect of it. Is it an evolving legislation that we begin to appreciate its learning and the evolution of our procurement laws? So that, for instance, Section 90 of the Public Procurement Act provide a mechanism for redress. So I remember one of the arguments that I made before His Lordship Justice Chebafo, because my clients at that time, Director General of the organization, entered into the contract. So the argument I placed before him was that, look, in the wisdom of the maker of the law, the fact that he provided a procedure for cancellation, ratification in the law, means that he envisaged a situation where a contract can be entered into without PPA approval and therefore can go for ratification. And that is why the legislator made that provision. And so if we've not gotten to the point where an opportunity, say, for rectification, cancellation, and all of those things, where the PPA will constitute a committee to investigate the alleged breaches and others and recommend whether the contract should be rectified, or cancelled, the point of criminality has not arisen. That view was completely rejected, and they were convicted. So, if you look at the detail in the KPMG report relative to the SML, there are specific claims of breaches of the Procurement Act, among other things. I want to see the view that the OSP and our courts, assuming this matter ends up in court, will take, so that it serves as a guide to all of us who are into public service.
Well, it's a fair point, and let me also at this point acknowledge the presence of the celebrated Kwame Ansah.
All of us, our boss.
Yes.
All of us, our boss. All of us, our boss.
He's a former director of the Ghana School of Law.
We've not celebrated this man enough. We've not celebrated this man enough. And maybe let me just join my colleagues here in celebrating him. Prof, we thank you so much.
Indeed.
We thank you. Thankfully, today, all of us are your sons.
Thank you so much for agreeing.
Boss,
indeed.
Thank you so much.
Yes, thank you for agreeing, waking up this morning to join us. Kwame Ansah, Kwaku Ansah, I beg your pardon, is a former director of the Ghana School of Law. And then also, we understand he was lecturing this morning and had to leave to join us. I thank you so much.
His mind is so valuable.
I wonder.
I made a very interesting point, which I think needs to be looked at again. You see, most of the bulk of our principles are derived from English law.
Yes, sir.
Now, procurement breaches or issues or questions pertaining to contracts, sale of goods, buying and selling, entering shops, where goods are, have been shelved and all that. An English court will first look at the general law of contract to see whether there have been any violations before even crossing the threshold to go into the area of criminality. Our courts have not, done that, and therefore the illustration he gave, which is analogous to a situation that occurred in a case they are all familiar with, Fisher and Bell.
Yes.
See, the court did not proceed immediately to make a pronouncement, but examined the surrounding circumstances to find out, whether the display amounted to invitation to trade or offer.
Right.
And then and only then did they proceed, to look at and apply the general law of contract to the issue that had arisen in Fisher and Bell, and said under the surrounding circumstances, no offense had been committed. But here, the court begins with a mindset, and the moment that mindset is consummated, there's conviction. I think the approach is wrong. That we must, our court, our judges must do a bit of analysis before implementing provisions of the Procurement Act, because some of the things may not be offenses, but because they arise from the Procurement Act, it is assumed that an offense
has been committed.
Yes, or there have been violations or breaches of.
In fact, this matter is a rolling stone, as I indicated. It's just evolving, but it's an important point that you make, Mr. Ansah, a former director of the Ghana School of Law. Like we said, on this, especially because the special prosecutor had indicated, and you're right. The last press conference that the OSP addressed, he indicated that by end of month, end of this month of June, some top officials of NPA specifically, and this whole SML matter were going to be put before court. And today is the 28th. So, yes, we'll see. Maybe on Monday, something will happen. But my question, this matter does and how it's evolved to this point.
In Julius Caesar, Shakespeare's book, write-up Julius Caesar, the soothsayer had informed Caesar that on the 15th of March, he will be killed. So late afternoon or evening of 15th March, Caesar reached out to the soothsayer and said, soothsayer, you just said I'll be killed on this day. Then he retorted. He said the Eid of March had come, but not yet gone. Or
yes, exactly.
So maybe give the
Monday.
To Monday. just a quick one on this. So I move on to the next
foremost, kindly permit me to commend Manasseh Azuri and then his former colleagues at the Fourth Estate.
Right.
Without them, we wouldn't have gotten to this far. I'm always happy anytime the state takes up some of these challenges that we have as a society. Now, we keep, in analyzing this particular situation, I came to the conclusion that if we as a country, we always say we are in leadership position, we take our position to help develop the country. And then in the end, the very people who have accepted to come and serve the country are the same people coming under this slogan, create, loot, and share. Then where are we heading as a state? And it's not one instance, it's not twice. Almost every now and then, we keep hearing this. And that is why I particularly had to commend the Manasseh and people, because it is not only this that is going on. There are several other situations. It takes the effort of some individuals or some citizens to be able to bring this to the fore. Now, let's say the OSP, whether procedurally they are correct or not, at the end of the day, they've been able to arrest some persons to kickstart the entire process. That said, I feel at the end of the day, once investigations are ongoing, by all means, they will be able to come out with something. I mentioned the create, loot, and share because if you read the story as captured from the investigators, everything points to the fact that this is a well thought out something, without necessarily trying to go into the merit because investigation is ongoing. But if you look at the persons involved, and it saddens me, at the end of the day, we had a pastor in there also, playing this sort of like double role thing. Some functionaries from the GRA, at the end of the day, were also seen playing some roles in the SML. So automatically, the ordinary citizen comes to hear of this story, and then we'll be able to conclude that then straight away, it came from some powerful element within the government. Now, I will also call for a review of the PPA Act. I think it's high time we did something about it. Before, we're all relying on Parliament, that some of the contract, some of the key arrangement from government will have to pass through Parliament. Then came the PPA also. But I think the major loophole that politicians often exploit is the aspect that the same act that we say go through ABC will then come back and say you can ignore all the ABC and still go for sole sourcing. And that is where the major challenge is. Then we ask the question, 2 years ago, we had some government officials at the embezzle fund. 5 years ago, some government officials at the embezzle fund. So the question is, what then was the role of Parliament? You see? So along the line, much as I am advocating for changes in the PPA, I feel as part of my recommendation, see, we shouldn't always be criticized. Sometimes we should also propose solutions.
Okay.
My recommendation moving forward, I think what will help us as a country and as a state moving forward is for us to have a very robust and strong institution that will not come directly from the government, but then an autonomous body. And if permission is given me, I will recommend a body like the General Legal Council to play some extra rules. General Legal Council, because the composition itself, we might not believe this, but the few time I have had the opportunity to meet some judges in private and then in court, I have realized that most of them are God-fearing. And then they are also principled in their doing, especially those at the Superior Court. Now, if you find the personalities we appoint to be part of the General Legal Council, I feel they will do a better job than any other body. Because Parliament has also disappointed us. And the people we appoint on to be on the PPA board, from the stories we hear every now and then, we often collude with them.
I'm not PENDREAM TV. Now, so far so good. Say open online portal e Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.